Hello, this is Matt on the Moon Lambo channel, and it's another bad day for the SEC as Judge Torres in the SEC v. Ripple case has granted applications from two separate businesses to file amicus briefs in support of Ripple. You may recall that one of them is an actual Ripple customer named AMICUS, and they're utilizing on-demand liquidity, which does mean XRP is a bridge currency. In fact, they recently expanded their adoption of XRP to help with the functionality of internal treasuries in different jurisdictions, different countries, utilizing different fiat currencies. And then there's also TapJets, which is basically a company that seeks to be, as they put it, Uber for jets. So it's obviously for the very, very, very wealthy. We'd say the uber wealthy, perhaps. But, there's a problem when outside of business hours, if you're on a whim, you want to charter a private jet, well, you got to pay for it up front. That's the way this all works. But how do you actually move money after business hours? What if it's the weekend? Banks are typically closed or barely open on Saturdays and Sundays, and are they going to facilitate any sort of wire transfers of funds? Well, crypto solves this problem, and XRP is heavily used by TapJets. TapJets stated that, I believe the number is 48% of their revenue, the sales they pull in, it's paid via cryptocurrencies, with XRP being the most important cryptocurrency among those that they accept. And why? Well, it's not a surprise, is it? It's accepted all over the place. It's one of the most liquid cryptocurrencies out there, settles with finality in nearly instantly, 3 to 5 seconds, uses almost no energy. There's all the benefits in the world utilizing XRP for this use case. And so these two firms filed an amicus brief recently, and I broke those down in separate videos, so I don't intend to go into that any further in this particular Moon Lambo hot jam. But the SEC fought back, and they said, nope, it doesn't make sense, and I made videos on that either, so I don't intend to rehash that, but I want to happily report right here, right now, that the applications to file amicus briefs absolutely have been approved. So I'm going to share with you the full story on that. Got some comments from an attorney within the XRP community talking about summary judgment. What's the timeline looking for here? Is it possible that we could have summary judgment come in perhaps a little bit sooner than is typically expected at this point? Plenty to discuss. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. To get things rolling here, first, shout out and credit to James K. Filan, who is an attorney within the XRP community. He shared this breaking news, which is from just this afternoon. Also, shout out and credit to John Deaton's crypto law organization, which did the very same. And so you can see it's very short, so I'll just read the whole damn thing here, but this is from Judge Annalisa Torres just this afternoon. The court has reviewed the request by AMICUS Inc. and TapJets Inc. for leave to file amicus curiae briefs dated September 30th, 2022. So I'll just pause and note what she's just saying, like, that's the date that they were actually filed here. And I know it's a little peculiar. I don't know the exact reason for this, but in order to file an amicus brief, you have to file an application in order to file the brief. But when they file the application, they file the actual brief with it. So, like, you already are filing it. So I don't get it. Why don't you just file it, and then if the judge doesn't want to accept it, okay. But, I mean, they basically already submitted it. She read the damn thing. So I don't know. There's probably some reason that I don't understand because I don't have a legal background. But just as an observer on the outside, I'm like, why ask permission to file it if you're filing it while you're asking permission to file it? It is what it is. Anyway, and then Judge Torres says, and the party's letter dated October 4th, 2022. Accordingly, the requests are granted. By October 14th, 2022, AMICUS Inc. and TapJets Inc. shall file their briefs. Amici are reminded that their briefs must comply with the requirements set forth in Section 3.d of the court's individual practices in civil cases. So ordered. Annalisa Torres. That's going to sting for the SEC because here's the big reason, without rehashing everything that was in this, because I've so thoroughly covered it, I don't want to in this video. But I will mention this. I'd be remiss if I didn't at least mention this as far as why this is tremendously significant. It's because what is argued by AMICUS and TapJets goes against some of the core arguments that the SEC asserts in this lawsuit. It just flies in the face. In terms of actual XRP utility, yep, because SEC's pretending like there isn't it. And there's all sorts of other stuff too. But they definitely didn't want this in, and Judge Torres is like, yeah, well, it's in. And so here's what Attorney Deaton had to say. He wrote, "Great news. The judge wants to have all info in front of her. The truth is all we need. And then we had this from XRP community member and attorney Jeremy Hogan. I am happy to announce that I was 100% absolutely wrong as to what Judge Torres should do, as she grants both requests to file amicus briefs, and both motions were granted without comment as to the SEC objections. I gotta tell you, that is somehow satisfying, because the SEC, they might put in the effort to say why they shouldn't be admitted, shouldn't be part of the case. The SEC did their best to argue against these amicus briefs, and then Judge Torres just like, yeah, I'm not even going to acknowledge that. Hey, it's granted. That's it. I don't even want to explain to the SEC why their perspective is completely and utterly wrong. There's something about that I kind of appreciate. And then we have Attorney Bill, then the XRP community, retweeting this story as it broke hours ago from Attorney Filan, and he said the following. Thanks, James. This is excellent. These briefs give important, unique perspectives to Judge Torres. If she finds ultimately against Ripple, it can't be said she was not made aware of the consequences. I think it is good she is aware already. And by the way, I wanted to mention this too. It looks like there's going to be even more of this coming in terms of more amicus briefs. Take a look at this. This is a tweet from Eleanor Terrett, who is a Fox Business journalist. And just this early evening, she tweeted out the following. Judge Torres has now approved 3 third parties to join the SEC v. Ripple lawsuit. The Chamber of Digital Commerce remains neutral, but stresses the importance of the court decision for the industry. 2 are pro-Ripple/XRP, and I'm told at least 3 more Ripple/XRP advocates will file soon. Woo! Something about that. There's already 4. Don't forget, because there's Attorney Deaton, there's the Chamber of Digital Commerce, IREMET, and TapJets. That's 4. And she heard through the grapevine somehow that apparently there's going to be another 3 coming out. I'm telling you, folks, this has never happened in the history of SEC litigation. Anytime they filed against somebody, most of them just roll over and most end up just settling with horrendous terms. But in this particular case, the SEC, I'm telling you, I really don't think that they understood the degree to which there would be tremendous backlash. They tremendously underestimated this community and what would come as a result of this. And when I say the community, it's not just speculators, not to diminish speculators. Like I'm a speculator. But think about all the people building on top of the XRP ledger, the innovators, the entrepreneurs. There are so many players in this space. It's a gigantic global ecosystem here. And they really thought, the SEC really thought that, Ripple just roll over. There's nobody. And then here you got over 70,000 people joining Attorney John Deaton to take this thing on head on. And then there was this story from You Today. XRP, here are next key dates in Ripple SEC lawsuit. And this story, I don't want to read the story itself, but it stemmed from this Twitter thread. There's a community member named Hashar Ventures who wrote, next up, Ripple/XRP case dates. And I don't want to read through all of them, but I did make it full screen. If you want to read, it's on your screen right now. There is an important date that Attorney Filan wanted to add. So he came across this, and he had the following input, and it resulted in a really interesting back and forth that I wanted to share with you. So Attorney Filan responded to that and wrote, if the SEC decides to file a motion for reconsideration of Judge Torres' ruling on the SEC objections regarding the Hinman documents, that would be due October 13th. So pause a note here. As I record this, I think it's the 11th, right? I'll look at my phone here to make sure. Yeah, it's the 11th. Okay. So that we're going to know within 48 hours-ish. And so what we're talking about there is, of course, there was Judge Netburn, who ruled 3 times effectively, you must hand over the Hinman Ethereum free pass speech, or free piece. I just said it completely backwards. You must hand over the Billy Boy Hinman Ethereum free pass speech emails and associated drafts, all of that, ruled it in January. Then there was another ruling in April that said, hey, you have to hand this over. And then there's another one in June or July. Maybe it was early July. I can't remember now. And then after that, so that was all from Netburn. Then you have the more recent one from Judge Torres, in which she's like, yeah, you really have to hand this over. I agree with Judge Torres. And this is, I'm just paraphrasing, obviously. But there's an opportunity that the SEC could ask Judge Torres to reconsider what she already ruled on this topic. And so if that's going to happen, we're going to know inside of 48 hours, because that's the deadline. Are they going to? I would not put it past them, and they do a lot of stuff last minute, so that wouldn't surprise me either. I don't know if they're going to, but it wouldn't surprise me if they do. Hashar Ventures responded to that and wrote, thanks for pointing us towards your thread. Is summary judgment in the judge's hands after December 2022. Okay, now this gets interesting as we're talking about the end game here. Summary judgment, that's where the final determination comes down. It seems highly probable that this case is going to end, if not in settlement, then in summary judgment rather than a jury trial, though it's still possible we could see a jury trial. Attorney Filand responded with the following. Technically, it's in Judge Torres' hands, and she can start work on it on November 15th because that's when briefing is complete. Those things due after that relate to sealing issues regarding what will be public and what will remain sealed, but not the substance of the motion. So there you go. Judge Torres can actually, as of November 15th, start working on the hard process of coming to a conclusion of how this thing's going to end, whether she makes a determination regarding summary judgment or if it actually does go to jury trial. But all the other stuff that's on the timeline that does have to be completed in terms of do certain documents get sealed, will the public see this or that, that's not going to impact Judge Torres coming to her ultimate conclusion in terms of summary judgment, right? But not the substance of the motions anyway, just to be clear. And then Hasher Venture says, gotcha. Have you ever seen summary judgment come in before the housekeeping, i.e. sealing? Yeah, so I think I might have said that exactly backwards. If I did, I apologize. But what I'm saying is she can start working on this, but in terms of the final determination, it comes when it comes. And then Hasher Venture says, and with SEC legal options still possibly ahead, would the summary judgment, if decided, be held until after they exhausted all of their options? And Attorney Filand says, I haven't. Judge Torres, I believe, will continue to work on the summary judgment motions no matter what is happening on the Hinman documents. I don't think she would hold her decision. And Ripple already said that it was prepared to go forward on summary judgment without the privilege issues resolved. So think about that. It seems like Ripple, based on their arguments and where they're going here, they understand, they seem to have decided that regarding the Hinman stuff, as repulsive as it is, and we all hate that nonsense, and it's pretty obvious there are pretty clear improprieties, in terms of winning the case and what's important and how to approach this, it doesn't really matter for the SEC v. Ripple case. Ripple seems to have determined that. So whatever happens on this front, Ripple's already washed their hands of it. Like, to them, it just, from what I've seen from them, and it seems pretty clear here, like, whatever happens. Like, it's not, because you know what their main thrust is, and they made it pretty clear very recently. It's that they're arguing that there is no contract. It's not just Howie. Yeah, so fine. We've talked about Howie for almost 2 years, ever since the lawsuit dropped. But it's this idea of if there's an investment contract, aka a security, well, then there has to be an actual contract. But if there's no contract, there's no investment contract. And so Ripple's really focusing heavily on that concept. There's no contract. We don't even have to talk about Howie. And of course, we're not talking about that. We don't even need to talk about this Hinman stuff. Because hopefully you never even get to fair notice. Like, I'm thinking that they're thinking they have struck such a strong hand, it's just not going to matter in terms of the best route, the best strategy, best foot forward to get this thing settled in favor of Ripple and XRP holders. That's what I'm looking at. That's what it looks like to me anyway. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.